Welcome, debtors and borrowers, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a Colorado bankruptcy and student loan relief attorney. And today we're going to be addressing the messy topic of bankruptcy and eviction. Does bankruptcy help with eviction? Now, to give you a brief analogy, I would say that bankruptcy is to eviction like a hammer is to a screw. Right? So if you hit a hammer to a screw, you're most likely going to break the screw and it's not going to go through the board. But occasionally it might just work. That's really the issue. That's really bankruptcy and eviction. Bankruptcy is not that useful for dealing with an eviction directly, but let's talk about the various issues. It's not that it's never useful. It's not that it's never useful. It's just that bankruptcy is really not a good tool. And the rules and exceptions can get rather messy. Even experienced bankruptcy attorneys may not remember them off the top of their head because, again, it's not a good tool, so we don't really use it that much for eviction. But let's outline the different rules and how eviction and bankruptcy work. So as a primer, just remember, as far as analyzing statutory law in general, all laws are going to set out a general rule. And then that rule will have exceptions. Okay, so that's the best way to sort of approach any sort of legal analysis. You got the rule, and then you look for, or the general rule, and then you look for the exceptions. So in bankruptcy, the general rule is the automatic stay. So the minute you file your bankruptcy, the automatic stay order goes in place. And what that is a pause against most legal actions against the debtor. So the automatic stay stops things like foreclosures, lawsuits, wage garnishment, collection, and yes, even evictions is in that category. However, the devil is in the detail and the devil is in the exceptions. And one of those exceptions to the automatic stay is eviction. So let's talk about those exceptions. So the first exception is that if the landlord already has the final judgment for possession or final judgment for eviction, whatever that is in your state, but it's just the final order saying, yeah, the landlord can take possession of the property, automatic stay doesn't apply. Bankruptcy is of no use to you in that situation. So if they've gone through the eviction process, got the final order, you're done. Bankruptcy is not going to help. Hopefully you have another reason to file bankruptcy, but you can't claw back the eviction after the final judgment has been ordered. However, there is one exception to that rule. That exception is whether state law, right, the law of your state provides for what we call a post-judgment redemption period. And all that means is that, okay, the landlord got the final order, but hey, the tenant still has, say, 14 days to pay all the back rent, then they can stay. That's a redemption period. So if your state law has a redemption period, then you can reinstate the bankruptcy automatic stay for the length of that redemption period, assuming you have the means to pay back the debt, and then you also have to deposit with the court any upcoming rent that would come due. Okay, so that's one exception. The other exception to the automatic stay is that if you're being evicted for illegal drug use or endangering the property, automatic stay doesn't apply. However, there's still a process a landlord has to go through in order to continue the eviction. So if you're being evicted for something other than back rent, and specifically illicit substances or endangering the property, the landlord has to file a certificate with the bankruptcy court saying, hey, this is why I'm evicting the tenant. The tenant actually will have an opportunity to dispute that. So there could be a back and forth process that takes place there, but the point is that the automatic stay doesn't apply if you're being evicted for those reasons. Okay, so we have the general rule, automatic stay stops eviction. However, there are exceptions, and those exceptions are the final judgment for eviction has already been entered, or you're being evicted for illegal drug use or endangering the property. Okay, so now let's talk about eviction in terms of the tenant's goals with the bankruptcy. So there's only really two things there. One is they are either going to try to stay in the property or they're going to move anyway. Let's talk about move anyway first. And I need to give you sort of a red flag caution here. If the only reason you're filing bankruptcy is to try to delay the eviction, that's bad, and that's going to be considered a bad faith bankruptcy. And in addition to not delaying the eviction, you're likely to have your bankruptcy dismissed for cause, and that's going to impact your ability to file a future bankruptcy and discharge the debts that would have been included in the bankruptcy that you had filed. Okay, so you need to have a good faith basis to be filing the bankruptcy beyond just trying to delay an otherwise legal proceeding against you, which is the eviction. So you need to have other debts. All right, so if you have $40,000 in credit card debt, your car's about to be repoed, whatever it is, payday loans, as long as you have some other reasons to file bankruptcy, then you're okay. But if your sole purpose is to try to buy some time in the eviction, that's probably going to be considered a bad faith bankruptcy. But now that we've covered that, well, how much time can you really buy with a bankruptcy? At most, if you're being evicted for owing back rent, which is the most common reason, how long you get will depend on how quickly the landlord moves to set aside the automatic stay. But at most, you're probably going to get about 30 days. And there's no reason for the court not to grant that order. The court's going to grant the order because there's no mechanism in the Chapter 7 bankruptcy to allow you to stay in the property, or at least not quite. Okay, so if you're behind on rent and you can't catch it up, and if you could catch it up, you probably would have done so anyway, then again, you're buying yourself a few weeks to about 30 days. However, there is one way you could stay in the property. So if you file the bankruptcy before the final judgment for possession is entered, and you have the means to pay back all the back rent, right, that way you will assume the lease in the bankruptcy, and then you have to pay all the back rent within 30 days. Right, so that's the sole mechanism that you might have to stay in the property. But as a practical matter, we just don't see that very often, right? Because if you're filing bankruptcy and you're that close and you're already in the eviction process, if you could have paid the back rent, you probably would have already. And let's just say it never comes up, like Grandma Jane's suddenly going to pay your back rent for you, whatever. So it's not like it never happens. But so there is this limited time process where you can file the bankruptcy, do what's called assume the lease, and then you got roughly 30 days to pay all the back rent. Okay, so that's if you want to stay in the property, or that's if you want to stay in the property. Other than that, really, bankruptcy is not that much help. The only thing the bankruptcy is really going to accomplish for you is going to discharge all the back rent, but you still got to move out. All right. So if you're trying to stay in the property, you have this mechanism to assume the lease and pay all the back rent, but you have a very short period of time to do that. If you're just trying to delay the bankruptcy, at most you get 30 days, and you better have some other reasons to be filing the bankruptcy before you embark on that path. Generally, what I suggest to individuals who are facing eviction and who talk to me about bankruptcy, it's like, look, save your resources, go move, deal with where you're going to live, and then we'll circle back to the bankruptcy when you're in a more stable position, because the bankruptcy is really not going to help you that much with an eviction. So I hope this conversation has helped you. Again, bankruptcy and eviction is like a hammer to a screw, right? You might get it through the board occasionally, but you're most likely to break the screw. So be sure to talk to a bankruptcy attorney before you embark on trying to file a case just to delay a potential eviction. My name is Matt Burkus, Colorado bankruptcy and student loan relief attorney. I offer free initial consultations for the purposes of bankruptcy. I do my consultations by phone. Best of luck to you.